What's up, everybody? Welcome back. I am back home. Literally just got home, and here we are. We saw this news drop yesterday. We saw another defense put up by Karen Reed's team, the new lawyer getting in the mix. We're going to read what he thinks about this process, what he thinks about the state or the Commonwealth, response to the defense's motion to dismiss that we reviewed and read through together. And then we're going to talk about the potential new judge. Is it true? Is it not? What would it mean? What do we think is going to happen in this July 22nd hearing? All that and more. Of course, we'll answer your questions. Please hit the like button if you guys haven't already, and make sure you subscribe. Let's get to it. So we're here. Sorry I'm late. It is my anniversary today. We've been celebrating the last couple days, so we're just chilling tonight with the kids, dinner, movie, hanging out. Glad to be home. Had to work for a couple hours right when I got home, though. Was really tired. We got up at like 4 o'clock to fly home today from Colorado. But I'm on this new wellness journey, folks, and you can come along with me. And been doing it for about 2 weeks. My most recent addition to my wellness journey is the cold plunge. Does anybody cold plunge? If you do, let me know in the chat. I absolutely love it. And I just did it 2.5 minutes on 43 degrees. That's my sweet spot. I'm going to try to work down to about 38, 39 degrees. But if you guys have any other wellness journey tips, leave them in the chat. Your boy's coming along. We're getting fresh. We're dealing with pickleball elbow, right? And some golf injuries and stuff. But we're feeling fresh. We're feeling spry. We've got energy, even after getting up so early, after being up late last night. And we're going to put all that energy into this Karen Reed case that has continued. And there's still a lot of questions to be answered. And there's still a lot of things going on. And to me, as long as the fight continues reasonably close to the trial, that's very different than an appellate process, right? The more stuff that comes out, the more immediate and close it is in time to the trial, the more likely something is going to happen. I have had some requests for the Black Swan trial. I have not watched a second of it. I don't know anything about it. I will see if I can catch up. I don't know how long it is. Do you guys know how long it is or how long it's been going? Or have they already done witnesses and things like that? Let me know kind of where we are. And if it's possible for me to try to catch up, I may, if you guys care about it and want me to. A lot of questions coming in. John and Kelsey, start some questions about my wellness journey. And we'll answer some of those at the end for the people that care, because I'm sure most people don't care. And I'm half kidding, half serious. I want to be healthy, right? I want to be healthy. So let's get into this reply first, what we can learn from it. And then we'll talk about what's going on with the judges, what that usually means, what's likely to happen, how will it potentially affect the case, if anything. All right, here we go. Defendant Karen Reed's reply to the Commonwealth's opposition to her motion to dismiss. Now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby respectfully submits this reply to the Commonwealth's opposition to her motion to dismiss. The Commonwealth's opposition is perhaps most notable for what it does not dispute. That, according to the information from 4 deliberating jurors, the jury had reached a unanimous decision that Miss Reed is not guilty on 2 of the 3 charges pending against her, namely counts 1 and 3. So what he's saying just right off the jump is she didn't dispute, or I should say the Commonwealth didn't dispute, that those jurors reached a unanimous not guilty verdict for counts 1 and 3. So from my opinion, they're trying to act like they ratified what the jurors said. I don't think that that's necessarily the case. I don't think the Commonwealth admitted that or purely failed to argue it. I think it was more of, that's not reliable. And because they didn't do X, Y, and Z in court, we don't even get to that question. I personally think that's what the Commonwealth was going with, but this defense attorney is going to take that lack of a denial as almost an admission that the Commonwealth also agrees they were not guilty on those 2 counts, which I would be surprised if the Commonwealth actually agreed with that. The Commonwealth's insistence that Ms. Reed must nonetheless be forced to run the gauntlet once more is based on several clear fallacies. First, while the defense was given an opportunity to be heard on other issues arising during jury deliberations, the appropriateness of a Tui Rodriguez instruction, the defense was provided no opportunity to be heard regarding the declaration of a mistrial. What's interesting here is, so I kind of was discussing during the defense's motion and the state's response that the defense spoke up in those two instances and they didn't hear. They're using it as the flip side of the argument that the judge gave them the opportunity to speak up at those two motions or moments, but not before she declared a mistrial. And technically, I think they're correct. And if they want to make that argument, they can. And they can continue to go forward and say they didn't get the opportunity to respond or make their argument. I personally don't think that's their strongest argument, because you can take the context of the whole trial. You can take their opportunity to object, their opportunity to speak up, even when the judge didn't allow them to, like they did multiple times. Okay. So I do think that that's important to point out, see it both ways as much as we possibly can. I personally don't think that's their strongest argument, but we'll see. All right. Rather, upon receiving the final jury note, the court sua sponte declared a mistrial with no warning of objections from the parties. Second, the jury's note did not explicitly indicate an impasse on all charges. Okay. So first off, I like to stick to the strongest arguments. And if I don't feel the common sense on an argument is very strong, I usually don't like to put it forward. And from my perspective, to say that there was no warning and they were completely shocked that a mistrial was called in this case, I'm not sure I agree with that, number one. And number two, the jury did not say that they were hung on all counts, but it's not because they weren't hung on all counts, but instead because they didn't know they could. And that could be a jury instruction inconsistency or problem more than anything else. Okay. To the contrary, it was readily susceptible to the interpretation proven correct based on information received post-trial from deliberating jurors that deadlock applied only to multiple offenses, including within count 2 and not to counts 1 and 3. So what he's going with there is they didn't say they were hung on all counts. And actually, after the trial, they came and told us they weren't hung on all counts. So we're using the context of what we found after the trial to look back at the trial and show they weren't hung to all the counts, and nothing in any of those notes or on any of the verdict forms said that they were hung on all counts. Third and finally, the defense respectfully submits that neither the Commonwealth nor the court carefully considered alternatives before declaring a mistrial. The record reflects no discussion of any such alternatives, including, importantly, inquiry regarding whether the jury had reached an impasse on all as contrasted to just some of the counts. So I've heard a lot of discourse and discussion on this on Twitter, online, in my DMs, in my emails, things like that. And nobody is really pushing these arguments. Not a lot of people are saying it wasn't fair because the defense didn't get the opportunity to say, well, are they hung on all counts, et cetera, et cetera. And I don't know what the reason for that is. I don't know if it's common sense. I don't know if people don't like those arguments. I still have heard a ton of arguments that there was a problem with the verdict form and they should have had boxes guilty, not guilty for each count. They did for each count, not all the lesser included, but for each count, yes. And they could have checked no on counts 1 and 3 if they voted on them. And they didn't. So the whole, like, what they want to do with the verdict form, I really don't think that affects this. And I think it's proven that it doesn't affect what's going on going forward because they don't mention it in their motion to dismiss, their supplement, or their reply. So if they're not even mentioning it, I don't think we need to discuss it as a very valid argument for the defense. To me, the only and best argument they really have is that the jury, in fact, came to a final decision that they still agree with today for not guilty on those 2 counts. And people saying, no, they couldn't have. Bev told them not to. Okay. So Bev reads the instructions. Again, I don't really want to repeat myself a million times, but as we've talked about in other videos, Bev, the judge, reads the instructions that the lawyers agree to. And if the lawyers really fought for a different jury instruction than Bev read, if the jury instruction was a problem, the same argument I just made, if the jury instruction that the judge read was a problem, we would see it in these defense motions, and we don't see it. If it comes up in a future motion, we can discuss it further. But at this point, I'm going to assume the defense did not object to it and did not ask the judge to use different language to make it clear to the jurors that they could have answered on some and not others, that they didn't have to get a unanimous verdict on all 3. So we can I can hear comments like this. I can get stuff like this on Twitter and via emails, and we can discuss it. But not even the defense is making this argument. Not even the defense is saying the jury instruction was a screw up by the judge and we made this argument and the judge dismissed it wrongly. They're not even making that argument. So it's hard for me to really dig into that as an issue, especially knowing that the lawyers have so much to do with the jury instructions. The lawyers literally write the instructions and agree to them, or they object if they don't, and the judge has to make a call. And if the judge screws up, you better believe we'd be screaming about it in motions like this. So that's my assessment on what the judge read and whether or not the defense thinks it's a problem. All right. By the way, I agree with the defense in this last point that it would have been great if we would have come up with alternatives and we would have explained to this jury that they could have come up with verdicts on some of the counts and not others. I think that would have been great. I think that could have solved the problem, but we didn't. And they're saying also literally they did argue it. Okay. So again, and you guys can have this discussion in the chat more potentially, but I'll just say Jackson absolutely did not argue for guilty and not guilty verdicts per count. We're not talking about the lesser included in count 2. He did argue about that. They edited the verdict form a little bit. She gave him an additional instruction, but there was already guilty and not guilty boxes to check on each count 1, 2, and 3. It's very different than what happened in the lesser included. Okay. So, that's how I see it. That's what I'm reading in these motions as well. The lawyers are not arguing what they argued in court before the judge. None of that comes up in their briefs. The underlying idea of the constitutional protection against double jeopardy, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense. And we're jumping out with some of their strongest arguments here. Double jeopardy, interest of justice. We cannot do this again if she has already been declared not guilty. We cannot do this again. If we do, it should be an outrage and people should have problems with it. People should speak up. People should make it known with their voice, with their vote, peacefully in the best and loudest way they can, because that is horrible and that should not happen. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. So I've heard rumblings, I don't know if it's true, obviously, but people are sending it to me, and that Karen Reed has put her house up for sale. Maybe that's true. Maybe it's not. Maybe it's because of the legal fees. Maybe it's not. I don't know the answer to that, but I will tell you, there is no doubt in my mind, and common sense would tell you, this is a financial burden on a criminal defendant to have to go through this twice. To have to go through this once is a financial burden. To have to go through it twice is incredible and can really affect somebody's life. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. And then they cited this case. At the heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm the government with a potent instrument of oppression. Because, listen, and this happens sometimes in civil cases, right? With the big companies, insurance companies, whatever it may be, Goliath, as they say. That's why these cases are David versus Goliath. They will try to milk a client dry or milk a small law firm dry that does not have the resources to pay for experts and fight the case for as many years as it takes. The same thing can easily happen with the government with its unlimited money and unlimited resources and unlimited investigators and experts, and an individual having to pay for all of this on their own. If they could just keep trying people one after the next, which does and can and does happen with mistrials, it is unfair and we can't allow it if there is a true verdict. And that's the big question here. And that's why I think if I was the judge, there would be no doubt in my mind that we need to talk to these jurors and figure out if there is a true and final verdict on counts 1 and 2. And if there is, there's no way they should be able to try those again. No way. Thus, whether the jury acquitted Miss Reed or alternatively was merely not deadlocked on the relevant counts, the Constitution compels the same result, dismissal. Given the unambiguous post-trial evidence, it would simply be wrong to require the defendant to obtain 2 acquittals from 2 different juries for the same crime. The Commonwealth's leading argument is rooted in pure formalism, that no verdict was entered on the record in court. See their motion on page 5. But precisely this formalistic mode of analysis has been consistently rejected by the United States Supreme Court and Supreme Judicial Court in a string of precedents spanning more than 100 years. I know you guys love a good history lesson in the law. We get some of that from this case from 1896. The reception of the verdict and discharge of the jury is but a ministerial act involving no judicial discretion. Basically, what he's saying is the jury comes back with a not guilty verdict. It's not like the judge can say, I don't care what you say, jury. This person's convicted and going to prison for the rest of their life. That can't happen. However, it may be in England. In this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense. So the judge doesn't have to, really enter a judgment, even though they do on the record. You can't retry a person if the jury acquits them. Another case says holding that judicial grant of a new trial prohibited retrial on double jeopardy grounds, notwithstanding the state's Code of Criminal Procedure did not authorize the trial judge to enter judgments of acquittal in jury trials. Indeed, the prohibition against double jeopardy was plainly intended to condemn the abhorrent practice of English judges exercising a power to discharge a jury whenever it appeared that the Crown's evidence would be sufficient to convict. So we don't want the government to be able to override the system, to be able to stand in the way of justice, to be able to do whatever they want and not listen to the voice of the jury. The Commonwealth's heavy reliance on Blueford v. Arkansas fails for reasons set forth in the defense's opening motion. The defense knew they were going to rely on this case. That's why they made it a big part of the first motion. I see it as distinguishable. The defense obviously does as well, and we're going to see more reasons for that. In that case, after the foreperson reported that the jury was unanimous against conviction on certain charges, the jury went back to continue deliberation. The foreperson's report was not a final resolution of anything, and there was no indication at the conclusion of the deliberations that it was still the case that all 12 jurors believed the defendant was not guilty of capital or first-degree murder. Here, by contrast, 4 deliberating jurors attest that there was a final unanimous agreement that Miss Reed was not guilty of second-degree murder persisting through the conclusion of the deliberations. And we should be able to find that out with simple questions, right? That's the important part. According to one such juror, Juror D, and that was the last and strongest juror potentially, we read through that together in a prior live, after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on counts 1 and 3? Alan Jackson Supplemental Affidavit, paragraph 8. Most importantly, unlike Blueford, this was not a case where the defendant was charged in a single count which incorporated lesser included offenses. Indeed, the Arkansas law at issue in Blueford did not even permit the jury to return partial verdicts of acquittal. Because again, that would be the lesser included like we had on count 2, but that's not what counts 1, 2, and 3. Those were 3 separate counts, not lesser included, which is a distinction that I think some people are struggling to grapple with in their mind, but it's an important distinction that the defense is going to point out in this case. Unlike in Blueford, this case was not a case where a defendant was charged in a single count which incorporated lesser included offenses. Sorry, I already read that part. The jury's options were limited to 2, either convict on one of the offenses or acquit on all. Here, by contrast, the defendant was charged with 3 standalone counts, and the state expressly allowed for partial verdicts on any charges with respect to which the jury was agreed. And again, I think this could come back to an error or a mistake in the jury instructions. The jury instructions almost read like it was just a lesser included. If you read the 3 counts, they sounded like lesser included. And even sometimes we were like, this is kind of weird. This is not how I usually see it charged in Florida. Is this a thing that Massachusetts does? So it was kind of strange from the jump, and it ended up being a problem. Go figure. Confusing things that don't make common sense end up being problems, and that's why we usually try to guard against these. Only if the jury, in fact, was deadlocked on all 3 should a mistrial on all 3 be declared. Any other result would require either a verdict, if a unanimous one had been reached, as the affidavits in this case reflect, or at a minimum, further deliberations. All right, let me answer a few questions here. Joe, 43 degrees. I'd be there with you in spirit. Yes, it's not for the faint of heart, but I love it. Francis, Peter, please tell people there's no politics talk in here. Happy anniversary. Thank you. Happy anniversary. It's also my birthday today. Happy birthday, Keisha. Black Swan is doing motions. Okay, I'll see if I can check it out and catch up. Jury selection is okay. So next Monday is jury selection. That'll give me some time to catch up. If you guys want me to follow the Black Swan case, I don't even know what the name of the defendant is. Let me know in the comment section of this video. If you're watching it later, hit the like button on this video, and that'll let me know if there's enough interest in it. I'll try to jump in. I literally know nothing about it. Lisa, happy anniversary to you and Whitney. Thank you so much. Danielle, been waiting forever for this live. I think the jury isn't going public with partial interviews because they are holding out for documentary money. Interesting. Have you guys heard of official documentaries? I haven't yet. Rebecca, may not be a popular comment. However, it was not in black and white. And in nursing, I always say if it wasn't written, it wasn't done. And we'll see. And, the cases give context to all of this. And that's what the judge is going to have to decide. John, verbal instruction from Bev said, only fill out the form when you reach verdicts on all counts, not on form, but she said this. I didn't hear an objection to it, and I don't hear the defense attorneys arguing it in these motions that was a problem, that was a reason to overturn this. Under your scars, the jury is not lawyers. Bev should confirm correct, filled out verdicts. She refuses to return jury third time, call mistrial immediately, bring the jurors, said talk to jurors in a minute, then hop on a bus, Gus sus. Again, I don't hear them mentioning her private meeting with the jurors as an issue, right? This is their time to make these arguments. You do not save an argument because you waive it. So if these things were issues, I think they would bring them up in these filings. My problem here is that the judge said if a guilty box was not checked, it automatically meant not guilty. None of the boxes being checked should not be not guilty. So that was specifically for the lesser included charges on count 2. She did not say this with counts 1 and 3. The defense attorneys, the prosecutors, nobody had a problem with the verdict slips for counts 1 and 3. At least that they argued at the trial. They may have pretrial. I didn't watch all of those hearings. The jury missed the boat on this one. They should have asked further questions, Rebecca. Sometimes it is hard for a jury if they don't know that they can even ask those questions. It's a really stressful and difficult time. It's a whirlwind, so I understand. I think in the interest of justice, and that's the point, if they voted not guilty, we should absolutely not do this again. This is black letter law. This is 101 stuff. This is simple justice that we should be fighting for, and we should find this stuff out. I think people are thinking counts 2 and 3 are the lesser included, right? And they're not. Counts 2 and 3 are not the lesser included. Count 2 manslaughter had lesser includeds within count 2. Counts 1 and 3 were their own standalone charges. Jury instruction seemed unclear for sure, Olga said. I don't necessarily disagree with that. I didn't love the jury instruction, but that's a lawyer's job, and it sucks and it's hard sometimes if we miss something. But if we miss it on the jury instruction, it's really hard to go back and argue it, and that's why I don't think we see it here. Is there a law that can bring the jury back since they were already released? So, Froggy Girl, there are situations where we can have jury interviews. We can ask questions of these jurors. We can't ask them, so what were you guys arguing about? Talk about your deliberative process. How did you come to the decision you came to? We can't ask those questions. We could say, did you vote not guilty? Was it unanimous at the time? And that's it. If they were to question the jurors on counts 1 and 3, would they be done as a group or individually, and which would be beneficial? Usually it's done individually. That's what I would assume would happen, and that's what I think would be most beneficial. So there's no bullying or jurors feeling like they have to fall in line. Happy birthday and happy anniversary. Thank you so much. Happy birthday to my dad. His birthday was 2 days ago. And then Rebecca, another happy birthday, and to assist us in having some fun. Thank you, Rebecca. All right, let's get back to it. The lack of manifest necessity to support a mistrial provides a second independent basis for dismissal. While there is no doubt that a jury deadlock may constitute manifest necessity, the Commonwealth unsurprisingly cites no support for its contention that a deadlock on some, but not all, separately indicted charges supports declaration of a mistrial with respect to all counts. Contrary to the Commonwealth's characterization as ambiguous, the jury note at issue here was facially susceptible to 2 alternative interpretations: that the jury had reached an impasse to all charges, or that the deadlock applied to only some of the charges. Example, on multiple lesser included allegations within a single count, such as count 2. The information received from jurors post-trial proves the latter interpretation was correct. The jury's failure to expressly mention its agreement on counts 1 and 3 is understandable in light of the court's instruction that it should continue deliberating until it had reached a final verdict on each charge. Jury, June 25th, 2024. So here is that's the instruction. Given that there was no deadlock on 2 of the 3 counts, it follows that there was no manifest necessity to dismiss the jury without receiving its verdict on those 2 charges. The defense does not suggest that the court was required to give the jury new options for a verdict, and that's important. The judge was not required to give new options for the verdict. Only that it should have asked straightforward question of which of the separate indictments the professed deadlock related to. And again, I think there are arguments on both sides that if you don't argue this at the time, you may lose it, you may waive it. But technically speaking, they're going to say the judge did not give them the opportunity to do that. And technically speaking, while if you watched it live and you listened to it, it may not make common sense. Legally speaking and technically speaking, I think it could be a good argument. I think it could win the day potentially. Sandy said, why can't jury forms just say guilty or not guilty, check yes or no? I've been on juries and they are complicated. So on count 1, which we looked at it again a couple videos ago, it was pretty simple. It was second-degree murder, guilty or not guilty. They easily could have checked that before flipping the page to number 2. I understand about the instruction. I understand about how it was confusing. But the slip itself was not very confusing with count 1. The instruction was, because it seemed like you had to do it all, it seemed like it was an all or nothing kind of thing, which it wasn't. But I don't think the slip for count 1 or count 3 was all that complicated personally. In essence, the Commonwealth's contrary position asks this court to close its eyes to the possible, or even as here, very likely existence of partial unanimous verdicts on some, but not all, separately charged counts to avoid the risks of juror coercion. The Commonwealth utterly fails to acknowledge that Roth, Blueford, and a juvenile are all clearly distinguishable because they all arose in the context of lesser included offenses contained within a single charge. And this is where kind of that confusion and it doesn't really make sense. Why did they charge it like this? That's where it comes into play. And it is a very good argument to make them distinguishable from those 3 cases because it is absolutely different to have 3 separate counts versus lesser included. In my opinion, the defense thought there's no way they're getting guilty on superior charge, so let's not object to must decide on all and risk the guilty of the lesser charges. Well, they would have been correct, right? That was the risk. The guilty on count 2 was the risk. So you may be right. You may be right, but because they weren't given the opportunity to argue it, they're going to use it here in their arguments post-trial. Charlotte, I'm a retired teacher and I used standard reading level analysis tools on sections of the jury instructions. Major significant passages were college level. Defense needs to be aware. I agree. And that's something we need to make sure jurors understand what they need to do. But I'll just tell you, I've sat in a lot of conferences with defense lawyers, criminal defense lawyers, and really prominent ones that they teach these classes and they speak to them. Usually, and I've also been in prosecutor conferences as a prosecutor and knowing what we want to preach to juries. Usually, which side do you think likes confusion? Which side do you think would prefer confusion in jury instructions? Put it in the chat. Defense or prosecution? Which side do you think? And I'm going to read through the comments here in a second. The Roth court's concern about coercion makes sense in that context. When the jury reports a deadlock on one charge, follow-up questioning regarding the possibility of reaching a verdict on a lesser included would imply that the jury should consider conviction on the lesser included. But this logic does not extend to the present circumstances, and no existing precedent cited by the Commonwealth requires a judge to disregard the possibility of partial verdicts when the verdicts would be on standalone separate charges, such as those in the current indictments. I think it makes perfect sense what they're arguing here. And I think the juror comments post-trial lock this in as true. Okay, so I see it split. Maybe about a third saying prosecution, 2/3 saying defense. Without a doubt, unequivocally, the defense usually prefers confusion, muddying of the waters, jurors that are falling asleep, jurors that may not understand or pay attention to what's going on. The defense prefers it. And there are some reasons why we don't have to kind of get into in this video, but that's usually how it is. It's not the prosecution that wants it to be confusing. It's definitely not the judge that wants this to be confusing. And we'll throw this up there, Century 21 Realtor. Yeah, it is more common for the defense to want it to be confusing rather than the prosecutor. Just found that interesting. Peter's poll is too confusing. You got me, Sam. You got me. Can it be considered waived if it wasn't asked? So, nick of time. That's a question for the appellate court, because you don't have to specifically ask them for them to have the opportunity to make the argument. So the appellate court could look and say, we feel like you had the opportunity to object. You had the opportunity to say something. And because we feel like you had that opportunity, we're going to say it's waived. Or they could say, because you weren't specifically asked, it wasn't waived. So it depends on how the appellate court looks at it. Karen, you would hope no one would want confusion. Ding, 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 Karen. Ding, ding, ding. I couldn't agree more. It's not about winning, right? It should be about truth and justice. So we finished this page. Okay. This case permits, or the rule 27B permits taking verdicts on less than all of the charges set forth in separate indictments. Duh, right? That's common sense. Where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts despite a deadlock on the other counts. Another case says, proving that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive a record and record the verdicts which the jury can agree on. I don't think the Commonwealth would argue with this. I think the Commonwealth would say they agree that if the jury would have come back with verdicts on two of the counts, then it would be double jeopardy. I think what the Commonwealth is arguing is that the jury did not come back with verdicts on those two counts. So I don't think anybody's going to agree with the defense or disagree with the defense here that they could have come with verdicts on two of the three counts, even if they were hung on number two. Can Karen Reed jurors be summoned for another jury duty? Aslan, they wouldn't be able to be summoned on this one. I think there's a period of time in every jurisdiction, I don't know what it is in Massachusetts, that you can't be called for jury duty against once you're picked for a juror. Chance, I felt the defense compromised on the verdict form because they could see they were pissing off the judge. I was tired of hearing that the judge was too tired to do this or that. So generally, I think people would feel that most criminal defense attorneys are confrontational by nature and it doesn't bother them at all. I definitely don't think it was bothering these defense attorneys, especially with the fact that they kept arguing and pushing and the judge was pushing back and seeming annoyed. And then later the judge would end up coming around and agreeing to them with what they wanted to do, right? Belinda, I understood dep jury isn't better than this. Shaking my head. David Reese, I'm behind. Judge Bev gave oral instruction that the jury was not to fill out the form until they had reached verdicts on all counts. It was included in the written instructions that the defense had agreed to. It was not included in the written instructions that the defense had agreed to. The defense can object to jury instructions and they can have the judge make a correction if she was wrong. I don't remember them doing that. In this case, maybe they did. I don't remember it if they did. All right. Affirming the trial judges. Wait a second. There is simply nothing coercive about asking a jury reporting a deadlock that fails to specify which counts the deadlock relates to. The single question of whether it's a deadlock is on certain but not all counts, and if it has reached unanimous verdicts on any counts. Affirming this case, affirm the trial judge's taking of a partial verdict on 2 of 4 separate indictments and observing to conclude that the jury could have felt pressure to convert provisional verdicts against the defendant into final ones and to abandon all doubt that they may have privately entertained runs counter to the clear instruction of the judge and amounts to mere speculation without any support on the record. Affirming partial verdicts taken after the judge asked the jury whether it had reached a verdict on any of the indictments. And frankly, I really, really wished this would have happened in this case, but it didn't. So now we have to figure out how to deal with it. Are we just going to forget the fact that a jury would have acquitted her on 2 counts? We can't. My, justice personality just cannot think that that is fine. But what I will say that people may get pissed off about, if one juror comes up and says that was not my verdict, it was not my final verdict, I was considering it, I may have compromised and done it, but I would not have voted that if we would have taken a vote on count 1, then I'll say no. As bad as that sucks, if it was 11-1, that still cannot be considered a not guilty verdict or an acquittal. And even though I wouldn't, they still have the right to retry this case. The inflexible prohibition on judicial inquiry regarding partial verdicts advocated by the Commonwealth would inevitably undermine defendants' important and constitutionally protected interest in being able, once and for all, to conclude their confrontation with society through the verdict of a tribunal they might believe to be favorably disposed to their fate. And the danger of unfairness to the defendant from multiple prosecution exists when a trial is aborted before it is completed, as well as when the defendant is actually acquitted. The Commonwealth's proposed rule would also undoubtedly hinder law enforcement's interest by precluding courts from asking whether a jury may have reached a guilty verdict on some, but not all, standalone counts. The Commonwealth's attempt to shift the blame to the defense overlooks the black letter rule that the prosecution alone bears the heavy burden of establishing manifest necessity for a mistrial. So this is another good point. You can't push this over to the defense. Well, they didn't do enough. Judge, they didn't tell you to ask for partial verdicts. Judge, they didn't tell you to do this. You can't burden shift. Everybody maybe dropped the ball there, but if we can fix it, right? A lot of times the stuff is waived, but if we can fix it, we should. So let's have a jury interview. Does it even matter whether the defense waived their objection by not bringing it up in real time? Would that really stop a judge from ruling that a verdict was reached on counts 1 and 3? I don't think it should. But I think certain arguments are less strong and hold less weight if you missed your opportunity to do it in real time. Deb, I think that the judge set the tone on jury asking questions when they asked for the cert report info. She said, you have everything you need with you now. My memory is not perfect, but I remember both sides agreeing to the judge responding with that. There was nothing improper with the judge responding to that. That's how every judge I would have tried a case in front of would have responded to that. And that was the appropriate response. They don't get that. They can't get that. Joe, is the trial court authorized to dismiss on counts 1 and 3 verdicts handed already? So yes, she can. She has discretion to dismiss those counts. Wouldn't the remedy just to appeal the verdict or prosecution to do the right thing and just retry on count 2? So yes, any of those things could be an option. The judge could dismiss, the prosecution could decide not to retry, or it could be handled on appeal. But why let it go to appeal if you know it's the right decision now as the judge? I meant jury instructions are so complicated. You're a lawyer, I'm a CPA, you get the language, most people don't. That's why we watch you. I completely agree with you, Sandy. And that's something that we do as lawyers, is we try to write these instructions in a way that anyone could understand them. We fail miserably a lot of times because one side will argue it's not technically correct to drop it down so much that anybody could understand it. And this doesn't mean drop it down like dumb it down like people are dumb, but certain language and the way law school teaches you how to think differently. They teach you how to write differently. They teach you how to read differently than your normal person. And that's what we have to kind of undo when we write these jury instructions. So are they going to talk to the jury? What are they waiting for? I don't understand the inaction. So we'll talk about that at the end on what's going to happen on July 22nd. The defense's request for the Tui Rodriguez instruction did not, of course, reflect any implicit concession that the jury was deadlocked on all counts, nor did it commit the defense to any position regarding whether the court should sua sponte declare a mistrial. A discussion with counsel, such as that occurring twice earlier in response to jury notes, and either the consent of the defendant to a mistrial or further judicial inquiry of the jury instead was required. It is indisputable that the court provided no opportunity for defense counsel to be regarding the declaration of a mistrial. I don't know if it's indisputable, but they might be correct. In short, and again, they're just comparing it to the opportunity they were given to be heard on other issues. How can you argue that the defense did not object? How can you argue that the defense did not object? Well, I can argue it because they didn't. And there were multiple times in the trial that they objected. They spoke up. They stopped the court. They said, we need to handle something, judge, right here, when the judge didn't necessarily give them an opportunity or was silent in asking them for what their position was on something. Now, I don't think the judge handled it perfectly. She should have said, anybody have an objection to a mistrial? Anybody have an objection to a mistrial? And she didn't, and they're making that argument. I'm just saying, if you hook me up to a lie detector and the judge would have asked if the defense had an issue with the mistrial, I would bet my house that they would have said, no, judge, I think a mistrial is the right call. Speculation, but that's how I feel. In short, mere silence, absent an opportunity to object, does not amount to consent. The cases relied upon by the Commonwealth are readily distinguishable on this basis or even support the defendant's position. This case says that where the trial judge did not ask defense counsel to comment on the possibility of a declaration of a mistrial, the lack of an objection from defense counsel cannot be construed as consent. And I think that's a very strong argument in the defense's favor for their position. The judge declared a mistrial upon the defendant's request, finding that the defendant plainly had the opportunity to object where the mistrial was declared after voir dire, a colloquy after the jury was cleared from the courtroom. So they're comparing it to those cases where clearly it was allowed and the opportunity was given to those defense counsels. And if it wasn't, then their silence was not held as being waiving any objections. In this case, the defense, as in the present case, was afforded no opportunity to be heard before a mistrial was declared. But there, the Commonwealth fails to mention the crucial fact that the jury's note preceded the declaration of a mistrial, expressly stating that the jury could not reach a unanimous verdict as to either of the two indictments. So they were specific. They said the two indictments. In this case, they did not. They weren't specific. They weren't clear. Was it to one, two, or all of the three counts that they were deadlocked? In those circumstances, while the more prudent course would have been to consult with counsel, the record did not show that such consultation would have produced any fruitful alternatives. Basically, what they're saying is it wouldn't have mattered. And I do think the Commonwealth, and I think Judge Bev, the door is open for her to say, based on how you responded after the first deadlock and the second deadlock, you would have agreed to a mistrial. Now, is that legit? Maybe, maybe not. But that's what they're saying here is based on the jury note, it would have been a moot point even if you would have objected as the defense counsel. The note did not expressly state that the deadlock applied to all counts, and it is patently clear from the affidavits submitted to support in support of the defense motion that consultation with counsel may well have produced a fruitful alternative, namely inquiry regarding the jury, whether the jury had reached a unanimous verdict on any of the three counts, which according to the information from jurors A, B, C, and D would have resulted in acquittals on counts 1 and 3. In any event, Fuentes did not alter the court's clear obligation, repeatedly reaffirming since the decision before declaring a mistrial that 1, counsel must have been given full opportunity to be heard, and 2, the trial judge must have given careful consideration to alternatives to a mistrial. And in this case, and I don't know specifically what all the alternatives that the court should have considered that are cited in this case, but really the only opportunity that Judge Bev considered in this case was sending them back to continue deliberations. She didn't really consider anything else. Rebecca said, I still feel that they don't know what they don't know. They don't know what they don't know. So that's why I would hope they would bring the jury in and ask them so we can know what we don't know. The Commonwealth cites no support for its suggestion that an attorney who receives a call post-trial stating the jury had acquitted his or her client must simply hang up the phone and not act on that information. I agree. No good arguments against that. The jury's agreement that Miss Reed is not guilty on counts 1 and 3 reflects the results of its deliberative process. Motion at 4. Not the contents of the jury's deliberation or thought process of the jurors. I agree with them wholeheartedly here. This case said that the trial judge did rightly loathe to examine the entire panel to attempt to determine the impact of the errant juror on the request of the jury. The defense is not relying upon the jurors to attest to any particular statement made or incident that occurred during the juror's deliberation, the effect on any of the jurors' votes or any juror's mental process concerning a verdict. So not the process, but the actual verdict. Rather, the defense is relying upon the simple fact that the jury's agreement that Miss Reed was not guilty on the relevant counts, permitting juror testimony that a mistake was made. We've allowed jurors to come forward and fix mistakes that were made on the verdict form. The permissible subjects of the juror contact listed in or by the Commonwealth are not exclusive, and the Commonwealth fails to cite any authority establishing that the fact of a jury verdict constitutes prohibited subject matter under Rule 3.5c. Belinda, sorry, I understood the DEP instructions to the jury better than the instructions to this jury. It was very confusing if I was a juror. Happy birthday to Papa Tragos, and God bless your beautiful family, Peter. Thank you so much, Belinda. And I agree with you. I thought like they were really long in the DEP trial, but they broke it down to simple questions that the juror knew. You answer this, you go to this, you go to this, you go to this. And in civil courts, sometimes we have a lot more control and agreement between the parties than in criminal courts. That's something I've recognized or realized in trying cases in both criminal and civil court. She gave an instruction that sounded like they weren't able to fill out the form until they reached a decision on all each of the counts that was misleading. Okay. We've gone through this kind of a couple times. Chloe, I don't know if you earlier in this video, we kind of dug into this a little bit more. All right. At the same time that the Commonwealth criticizes the defense for purportedly infringing upon the jury's deliberative process, it also paradoxically faults the defense for reliance on hearsay. But the affidavit by counsel in Commonwealth v. McCallop attesting to the alleged juror bias was no less hearsay, and the Supreme Judicial Court squarely held that it entitled the defendant to further inquiry on the subject. And that's really, in my opinion, the most important part. We need further inquiry on the subject. That's what we've been saying. The defense submits that the same results is warranted here. For all of the reasons set forth above, as well as in its opening motion, supplemental memorandum, attached affidavits, the defense respectfully requests that this honorable court issue an order dismissing counts 1 and 3, or at least, I'm adding this part, doing a juror interview, inquire into these jurors to see if that was in fact their case on those 2 counts. So hit the like button now if you guys haven't already, before we talk about this potential judge issue and get into what's potentially going to happen. And make sure you guys subscribe to our page. I think the biggest issue is that the jury wasn't expecting the declaration of the mistrial and felt they were going to get further instruction regarding the counts. I don't know. They came back, 3 times saying they can't make a decision? And they weren't specific on the counts. I don't know what the jury knew, right? I don't know. And we may never know those things. Just hope more jurors submit affidavits. Happy anniversary. I agree, Iron Rabbit. I agree. All right. So Hope and Kindness said, I read Judge is being, Bev is being replaced. Is this true? And then Stacy said, have you heard there's a new judge for Monday? Not sure if that's just a rumor. Thank you for all the coverage throughout this trial. So Mr. Rubin, who is a subscriber here of the channel, emailed with the JA and said that Judge Bev will be there on July 22nd, and she is still handling the case, even though I think she's becoming a civil judge. It's not unusual for a judge to stay on the case. I would think Judge Bev would stay on the case. She knows it just for judicial economy and resources and time and understanding. And she's already made a lot of prior rulings. It may be difficult to throw a new judge into this fire. Stuff's happening on the YSL case. My dad and I are probably going to do a video on that tomorrow, breaking all the stuff that's going on there. Another judge has been recused. That case is just nonstop. But I expect Bev to continue on in this case. Now, sometimes magistrates or other judges will come in and handle individual hearings for judges. I don't know if that happens in Massachusetts, but if a different judge was to handle the hearing on July 22nd, I would be shocked if they handled all of these motions to dismiss issues. I would be shocked if they were coming on and handling those issues if they weren't going to take over and handle the entire trial. If they were going to handle the motions to dismiss issues, they should also take over the trial. If Bev is going to handle the next trial, then she should handle all these motion to dismiss issues. And that's how I think it should go, is Judge Bev should handle all of this. But it's not unusual sometimes for a different judge or a magistrate or some other judge to come in just for scheduling purposes. They can have Judge Bev's calendar. If there was a new judge, I would have guessed that this new judge was just going to say, okay, let's pick a new trial date. When do you guys want to try it? Does that work for the defense? Does that work for the Commonwealth? Does that work for all your witnesses? And that would be all that new judge would handle. And then these motions would still be kicked to whenever Bev was available. I also would think that was weird because I thought Judge Bev picked this date because she was available, because the defense was available outside, I think, Mr. Jackson, and the Commonwealth was available. That's why I thought she picked these dates. So I think, and Mr. Rubin said that the JA confirmed and that the docket is now updated, and Judge Bev can and will be handling this hearing on July 22nd. I can't confirm that personally, but we are going to be reacting to that hearing. I can't wait to hear what happens, and I really hope Judge Bev does the right thing and allows a juror interview. Joe, so Judge Bev can reverse the mistrial and enter not guilty verdicts on counts 1 and 3 if the facts are confirmed. I thought mistrial essentially nullifies the case. So she wouldn't be entering not guilty verdicts. What she would be doing is dismissing the charges on double jeopardy grounds. She would find that the jurors came to unanimous verdict, and therefore, in the interest of justice, we can't put her with Karen Reed in jeopardy again for a second time on the same set of facts and circumstances and counts that a jury has already acquitted her for. So she's going to dismiss those charges, not necessarily entering a not guilty verdict. All right, Olga. Wish I could watch the entire live, but have to leave. Regarding your health journey, I've done the polar bear plunge during January in Kansas City. Oh, I can't imagine what it's going to be like when it's cold outside. That's the one good thing about it being hot as heck in Florida is the cold plunge feels amazing. But I'm learning when to do it, not after the gym to crush the gains, right? But I like to do it for energy. I like to do it after pickleball or after, any kind of cardio for recovery, but not after lifting weights. So I'm learning all that about it. It helped my sinuses and I had no aches and pains for 2 days. Happy anniversary. Yes, it is helping the aches and pains. It's helping clarity, which I love. It's helping give me energy, which I love. There's no more euphoric feeling than getting out of it and letting your body heat up naturally. I love it. I promise you I'm not going to become somebody who talks about this all the time, but I'm interested in it now. So we'll see. Lady Los Angeles said, why were the forms never taken into consideration? I don't know what you mean. The forms were taken into consideration. They were discussed. They were agreed upon. When they had an issue, they discussed it on count 2. So they didn't discuss counts 1 and 3. So I don't think they had a problem with those forms. Will you be checking on the Richard Allen case? A lot of shady stuff between the attorneys and the judge, kind of like with YSL. Where is the check and balance? I have done some videos on that. I think a lot of that is done without camera, so it's hard to really follow everything, but I know so much is happening in that case. And when it does go to trial, I will absolutely be covering it. Don't be hating. What about doing an interlocutory appeal for burying evidence and purposely deceiving jurors in regards to inverted video? I don't think that is necessarily the appropriate measure to be taken. I think they are taking the best steps right now to get the quickest and most just result. Thank you, Danielle Cole, for the super sticker. Sue Lima said, I think the judge didn't pull them on purpose, potentially, but I see people saying they don't usually pull jurors in these situations, and I can understand that as well. I think the defense would have had to ask, or the Commonwealth would have had to ask, did you come to a verdict on any counts? But imagine if that would have come back guilty. If that would have come back guilty, the defense would have argued, no way, that wasn't a verdict. We had to coerce them or push them to give it. And I think they would have been right in doing so. Max Sauce, I love cold plunge. Did them at a wellness retreat in Costa Rica last week. Make your own fresh pressed juice is also great for wellness training. I love me some juice. I assume you mean like vegetable, which I'd have to mix fruits and vegetables. I've had some legit juice before when we were in California. It's all the rage. And I can go for a good juice. I could. Smurf Anna, have you looked into supplementation on your wellness journey? Yes. I'm looking into it. I'm wading in the waters. I'm trying to figure out what's clean and what's the best and what works and what doesn't. So yes, I'm just dipping my toe in the water. Aslan says, how is your golf game? So what I'll say is that course is absolutely amazing at the Broadmoor in California. I absolutely love it. I want to play it every time I go, but the greens were clown greens. It was crazy hard they were. I was playing with rental clubs. I have every excuse in the book. It's Colorado. The ball travels further than Florida. It was hard to dial it in. I also just didn't play well. The driver was great. The woods were great. The putter was great. The irons just were not great. And then it was tough out there in that rough. I think I shot 88 or 89. It was not good. It was not good. But it was fun. Blessed Mom from Texas, welcome to you and all the new members. Did you know they sell portable ice bath kits online? So I got a nice one that I love. Maybe we'll talk about it later. I was planning on doing some stuff for the Lawyer in Shorts channel, kind of the laid back chill channel, or maybe some members only videos on it. I've got to figure out, if I want to mix it in. You guys probably don't care about it, so I may only just do it at the end of videos. So the people that are here for the legal content, we get right to it. We dig in. We get all the questions answered. So I don't waste your time with this stuff. No idea why YouTube typed it twice. I was trying to make us pay double. So yeah, sometimes it just comes in twice. It never charges you double when it puts it in there twice. It's just kind of a glitch, and it happens sometimes. We talk to them about it, and they are working on it, but it never charges you twice to do it double. Nancy Joe, I will give 25 memberships if Bev dismisses with prejudice. She hates the defense. Ooh, Nancy, that's fun. That's fun, Nancy. Even more reason we hope she dismisses them now, right? Justice and for Nancy's memberships. Art Reese, will the criminal's trial have to be finalized before the O'Keefes can file a wrongful death civil trial against Karen? No. So they don't have to wait. Sometimes they do because it can be something that's already been decided, res judicata, as we say, but they don't have to wait. Lots of times civil cases go on at the same or even before criminal cases. Juror D indicated they were surprised that it just ended with no further instructions, and boom, on the bus, they said it was abrupt and unexpected. He didn't necessarily, I can't remember, but I don't think he necessarily said what he did expect. But I don't know. We'll see. Maybe that'll come out in the interviews. Chloe Albert's revenge. Other law tubers have said there is no precedent for this, so there isn't anything they can do. So at what point is precedent set? Why can't that be done here? I think it can. And in the interest of justice, that's how we make lots of decisions. And I think if they talk to the jurors and they say it was a unanimous verdict, I think it should be dismissed in the interest of justice. That's my opinion. That's my opinion. All right, folks, I'm going to get out of here. Hang out with the fam. Work done for the day. Hit the like button if you guys haven't already, please. And make sure you subscribe to our channel. And tell me what's next. Tell me what you're following. Tell me what you're watching, because the docket is a little bit open here. We just finished a couple trials kind of at the same time with Baldwin, Daybell, this trial. We're still following YSL and the aftermath of a lot of these trials. Katie said, what about the federal investigation? Is that still ongoing? It seems like it is. If there is a result that's public, we'll have to go ahead and watch. Kat says, I'm a little shocked that you don't think that the defense should have spoken up when they had the chance. I absolutely think they should have. I wish they would have. My dad gave a breakdown on, somebody asked about this defense attorney, this new one. My dad gave a breakdown on him. He actually knows him and had cases against him. So go watch the last video we did on Reed that my dad was actually there for, and check out his comments on it. All right. That's all we got, folks. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.